August 2026. And then phase 3 is the analysis and drafting phase of the task force's work. This will be from August to September of this year, and it'll be when the task force draws on all of the public comment that it's received, as well as the various areas of expertise that the task force members bring to the table. The task force will work to kind of summarize and synthesize those recommendations and the expertise into any recommendations or proposed solutions that they determine are helpful to submit to the legislature by that October 1st deadline. And that October 1st deadline is in phase 4, so that's the report phase. That is when the task force will be submitting its recommendations if they exist, or any other information that it would like to share with the legislature by the October 1st, 2026 deadline. This is just another way of looking at the 4 phases. I know this is super tiny up here, but this can be accessed through the IPRA microsite. If you just look up IPRA microsite, you'll be able to go to all of the relevant information that we have published about the task force, including this meeting schedule and work plan. So this details all of the different places that we've been so far, and then, as I said, the 3 upcoming meetings as well. The meetings all will have a subject matter focus, so today's focus is technology. Yesterday's meeting in Gallup was staffing. And I also want to make special note that the task force has asked for quantitative data in addition to qualitative data. So if anyone who has received or deals with IPRA requests, or IPRA requesters have information on how many requests they submit or receive, how long it takes for them to either process or hear back from those requests, the task force welcomes that type of data. I'm now just going to briefly run through the stakeholders that were specifically enumerated by the legislature in HGM2. So this includes public and governmental entities, public schools and districts, institutions of higher education, the judicial branch of government, so this includes both defense attorneys, records custodians, district attorneys, and public defenders, and then broadcast journalists as well. And we also want to make special note that while these are specifically enumerated in HGM2, the legislature also discusses any other interested and affected parties. So if you have anything that you would like to share about your experience handling, either receiving or submitting IPRA requests, the task force welcomes that input. So that brings me to the end of the brief introduction. These are some online resources that may be useful. The QR code on the left is to the IPRA Task Force microsite. As I mentioned earlier, that'll have a lot of relevant information about the task force's work. That includes recordings of past meetings, AI-generated transcripts, meeting minutes, and other information about the task force. The QR code in the middle is the text of HGM2, so if you would like to look at what the legislature has specifically detailed the task force's goals and compositions to be, you can access it through that QR code. And also just looking up IPRA Task Force microsite or looking up HGM2 2026 New Mexico should lead you to either of those resources. I also want to make special note of the email address at the very bottom of the slide. If you have any comments that you'd like to submit in a written form, please do so and submit it to iprataskforce@nmdoj.gov. This is the official email address for the task force. Please do not email any task force members directly. We're trying to collect all of the public comments to that email address, and we will be sharing all public comments submitted to that email address with all task force members. Thank you so much for your time, and I'll also be available after the meeting if you have any questions.
Thank you, Ms. Ritzky. We'll now go to the heart of our agenda. That's the public comment period. As Ms. Ritzky noted, we've been all over the state. We've been from Clovis to Alamogordo to Silver City, Gallup, and Farmington. But this is our eighth visit to a community to get public comment. So with that, I'd like to invite anybody here to share any comments they have for the task force. We ask that you keep it under 3 minutes, just so that we can get everybody in. In some locations, we've had an opportunity to do a second round as well. Folks had more to say. So Ms. Ritzky will have a microphone. We'll bring it around to you. Please identify yourself so that the task force members know who they're hearing from. So please say your name, and if you're associated with an organization, say that so that provides the context to the task force. Anybody interested in providing comments?
I'm Andrea Jones. I'm the city clerk for the city of Farmington. I've listened to the majority of your meetings, and Farmington experiences many of the same issues that have already been expressed. We support additional protections for minor victims regardless of who created the record, protections from abusive or vexatious requesters, a process for remedying a complaint along with a compliance period before fines begin, removing the requirement to forward a request to the correct custodian, and removing the initial 3-day communication requirement. The Farmington Police Department has its own records division and has faced the enormous increase in requests that require extensive redaction and staff time that most entities are facing. My office facilitates all other types of requests, and today I want to focus on the need to address requests for email communications specifically. I'd like to provide you with an example that also dovetails into vexatious requesters. John Doe submitted 552 requests in 79 days between August and October of 2025. 42 of those requests remain open. In 2026, John Doe has submitted 47 requests, of which 18 are still open. All of the open requests are for email communications. For perspective, my office facilitated 480 total requests in 2024. A sample request from John Doe. Please provide all sent and received emails for all City of Farmington employees for 2025. I believe that is a reasonably specific request and therefore it cannot be denied. I've used some conservative estimation to provide you some numbers for this single request. We have an average of 950 active employee email accounts, and I've estimated 7,500 emails per account. That's 7.13 million emails for one single request. One full-time employee working an entire year on this one request would need to review 57 emails per minute. 5 full-time employees would each need to review 11 emails per minute. 10 full-time employees would each need to review 6 emails per minute. Financially, estimating an annual salary with benefits of $50,000 per employee, this one single request will cost over $500,000. And that number doesn't include IT staff time, server download time, or the conversion time in case guard to even begin processing the request. Something really needs to change, and I have a reasonable suggestion that is similar to the requirements for requesting police video or audio. A request for release of email communications shall specify at least 2 of the following. 1, the sender's name or email address. 2, the receiver's name or email address. Or 3, the date or date range and at least 1 of the following. A, specific subject. B, keyword. C, exact phrase. I believe this would provide for targeted searches and significantly improve fulfillment times. In regards to your discussion yesterday and keeping this single example in mind, I can't advocate for increased IPRA staffing if nothing reins in the sheer number of records that can be requested. I also can't support state statute dictating the order in which requests are processed. If it did, no one other than John Doe would get a single record from my office for several years.
Thank you. Do we have any questions from any members of the task force? Ms. Moskowitz, go ahead.
Yeah, thank you for your comments. That's really helpful. My question is about your specific example request, and you said you thought that was a request that was reasonably particular with respect to the statute, because you know, it's not opinion, just a sort of initial reaction. It does not sound especially particular to me, and I'm curious what might be going into your office's analysis there.
So we know every employee, we know their employee email addresses, and it's a specific time frame, January 1 to August 29th, 2025.
Any follow-up, Ms. Moskowitz?
No, that's helpful. You know, I think we were having some of this conversation yesterday about what reasonably particular means, so I was interested in just sort of how folks are interpreting that.
Thank you. Mr. Smelter, go ahead.
If I might just ask the speaker, you referenced John Doe. I'm curious whether the requests were actually submitted under the name John Doe, or you just did that to not make it about the named individual.
I left it as a anonymous name. So a specific person did provide their name and contact information.
Understood, thank you.
Ms. Mills? No. Any other questions? Thank you. Oh, it sounds like we do.
Oh, Mr. Chairman, I was curious if the speaker could submit their comments in writing. I did think they had a pretty specific proposal around email searches, and I thought that was a helpful point, because there's not a lot of clarity around what constitutes reasonable particularity, and I thought that was a thoughtful comment.
Do you want to do it?
I can do that.
Thank you so much. Any other questions? Thank you so much. Is there anybody else interested in the public comment?
Hello, my name is Jack Fortner, I'm the district attorney here in San Juan County. One of the things that I had a concern with were the act says law enforcement records are public records except, and it says under number 1, before charges are filed, we're not to give names, addresses, contact information of individuals who are victims or even witnesses. And it's my preference that the before charges are filed should completely be eliminated. And that's one, to protect the victims and victims' family, because sometimes the defendants on their own, sometimes when they're in prison, will request all the personal information of people who are involved in their case. And I believe for safety purposes that at no time should names, addresses, contact information be released of individuals who are victims. Along those lines, I can't tell you exactly how to do this, but I think there should be some kind of restriction on inmates who are doing a certain amount of time in prison. Because at the DA's office, we get requests from inmates, and they're voluminous requests, and I think really what they're trying to do is try and make so many requests like John Doe to try and simply get an error so they can file a lawsuit and get attorney's fees. Another restriction that should be considered, and I don't have the exact language, but sometimes when an employee is let go, fired, or quit, a former employer decides to make requests that really aren't relevant to their employment, and instead it's simply done to harass. And so perhaps some kind of restriction that a former employee could make a request, but after a certain amount of requests, that it has to be done through his attorney. And then finally, the thing that really concerns me is it says records pertaining to physical or mental examination and medical treatment of persons are exempt. But then it says unless the information could be relevant to a criminal investigation. Well, if it's in our file, then it's going to be deemed relevant to criminal information. And I think, you know, HIPAA does not apply to the DA's office. So simply because we were able to get the records by subpoena from a provider, does not mean that HIPAA should no longer apply. So I think there needs to be some kind of restriction that protects people's medical records, mental health records. That's all.
Thank you. Do we have any questions? Go ahead, Ms. Moskowitz, and then we'll
You mentioned requests from people who are incarcerated and that you think their goal is to be able to file a lawsuit and get attorney's fees. How many of those folks have been successful in filing an IPRA lawsuit?
I can't tell you the exact number, but I know when I came into office a year and a half ago that we were settling a lawsuit with an inmate. And, usually they're requesting things that, number one, their attorney should have provided or probably did provide. And so, and again, what I'm trying to say here is there needs to be some kind of guidance so they can't just do an absolute request for everything, especially that they already have, and including the personal information and contact information of victims and or witnesses as far as that goes.
So your concern is more about those types of information and not about the litigation?
No, I'm not so concerned about the litigation, but that's what will happen. Sometimes we'll get more than one request in a row, you know, from an inmate that some may not be relevant to their case. So that's why I'm saying some kind of guidance, some kind of restriction on what an inmate can request.
And is your suggestion that they should only be able to request items relevant to their case?
Well, I think if they're an inmate, that there should be some kind of restrictions as opposed to if you or I are requesting or making a request for inspection of public records. I mean, the idea of the Open Records Act is, of course, to protect New Mexicans for, you know, having access to open government. You know, in fact, when the law specifically says New Mexicans, and so the question is, should there be a limit for those requests that come out of state or even out of the country? Because the law says New Mexicans and doesn't talk about those out of state or out of country.
Mr. Williams, go ahead.
Yeah, thank you, and thank you for being here, appreciate it. My question just has to do with what you said towards the end of your statement about the exception for medical records, more or less. It's the first I've heard that one brought up, and I'm a little curious about what medical records are typically contained within the files of the district attorney's investigative
If there's
records. And how often do you actually get IPRA requests for those?
well, from an inmate, they'll request an entire file, and if the victim was a victim of a sexual act, whether it's a rape, criminal sexual contact, criminal sexual penetration, there will be medical records when they've gone into the emergency room, and then there may be mental health records for someone who seeks counseling. And so in any case that involves a sexual assault, we'll usually request those medical records.
So you're talking mostly about criminal defendants
Yeah,
who request
well, not only criminal defendants, I mean,
in that file, depending on the charge and the incident, might include medical records.
that's correct. But I don't think the limit should just be to criminal defendants. I mean, I don't think that you or I should have access to someone's mental or medical records just because they were a victim of a crime.
Thank you.
Thank you. Yes, sir.
Any
Hello,
other-
Kim.
Any other questions? Mr. Stalter?
I'm curious about that, particular, and thank you, Mr. District Attorney, for your comments, and thank you for being here. I'm looking at that particular, exemption, and I'm just curious, it sounds like you're reading it at, kind of the exception to the exemption says unless the information could be relevant to a criminal investigation. And then it says, or an investigation of misfeasance, malfeasance, or other suspected violation of law conducted by a person elected to or employed by a public body. That's kind of a mouthful, but I guess, my question is, are you reading it that the exception to the exemption applies to any criminal investigation rather than only those into conduct by a public official?
No, I think it applies to any. I mean, if it's relevant to a public official who's committed a criminal act, then those records, I believe, are discoverable. But I'm talking about victims, because it says before charges are filed, it's protected, but once charges are filed, they're no longer protected. And we get the records from the hospital or other medical provider. HIPAA applies to them, but once they're in our possession, HIPAA no longer applies.
Any follow-up questions? Or any other questions?
I had a question, Mr. Chairman.
Go ahead.
Mr. Fortner, I was curious, like, one of the issues that I think the law has struggled with is that when these records are, I was curious how these records are handled when they are actually used to prosecute someone, because I think one of the challenges is that, or the argument I've heard is that, well, if they're discovering a criminal case and they have to actually be used as evidence, they are presented in open court, essentially, at some point in the proceeding. And so I've never practiced criminal law, and so I actually just don't know this specific issue that well. I'm kind of curious how, if there's a prosecution involving that type of evidence, how that evidence is handled.
Well, yeah, not in every sexual assault case will the medical records be necessary to be part of the evidence. But if there's a question of consent, and then the medical evidence needs to show that there is the evidence is consistent with an assault or violence, then we would want the medical records in. And obviously, once they're in evidence, that's different. Because then they become a public record of the court. And then they could, if someone wants the records, they could make the request to the court.
Yeah, I thank you for that insight. One struggle I've had is that I personally don't like exemptions that, I like exemptions based on content, not just really procedure, because I find that the procedural exemptions are very hard to track. So for example, if for example, a police department also has the medical records and the law were to say, these records are exempt unless they are admitted into evidence, it then becomes very difficult to determine whether or not they were in fact admitted into evidence. And so I think you've raised a really important issue for this task force to consider, because we've had this issue at the city of Albuquerque as well, where police reports will quote from medical records, they will extensively cite them, they will attach them, and it's really unclear whether or not those records are exempt. And to Mr. Williams' question, they are not, these are not requests that are just from the defendant, they are from everybody, so.
Ms. Martinez, go ahead.
Thank you. Just to add on to Ethan's point, in addition to the medical records, we also see a lot of the content that would come from medical records in body-worn camera footage or in the audio recording. So as records custodians, it's really hard to parse out, okay, like what is a, medical condition, can you redact, someone's mental status, based on, the conversation that's taking place, like between the officer and like others involved, what kind of medications did they find or are being used, like all of that comes into these videos, and whether they're, like the videos during body-worn camera footage, and people request these all the time.
Any other questions of the district attorney? We'll have plenty of time to discuss amongst ourselves what we're learning. Thank you. Is there anybody else who would like to make comments?
Good
Good evening. I'm Carrie Carpenter. I'm a vice president with San Juan College. The records custodian responsibilities fall within my area. I just want to thank you for convening this task force, and I thank the members of it for serving. It's an important topic. First of all, I want to make clear that San Juan College supports an open and transparent government, a free press. What we would respectfully advocate for are reforms that create a better balance between open records and the impact that this can have on public entities. And I would advocate specifically for two changes to be considered. One would be to charge a reasonable, not overly burdensome, but a reasonable fee for staff time in compiling and responding to requests. In higher education, for example, FERPA laws require us to redact student record information before production. That's sometimes hundreds of documents that require manual redaction. And so a fee for staff time would not be overly burdensome, but sufficient so that a requester has a shared investment in the request, I think is a good thing to consider. Requests, they divert the duties of public employees who are being paid to perform those duties by taxpayers to address that request. I think a shared investment in that makes sense. The second thing that I'd like to advocate for and to be considered is an ombudsman option. San Juan College, along with I'm sure many other public entities, they need to seek legal advice to determine whether exceptions under IPRA exist. I think records custodians, they're human beings, they're doing their best every day to apply their judgment to requests, but sometimes it's complicated and complex. An ombudsman could act as a resource to work through requests. Also, an ability to cure if a document was missed, rather than go straight to costly litigation. I don't think that was the original intent of the IPRA statutes, but I think an option to cure is a really important thing to consider so that there's an option to get it right if something was missed, if an error was made. When you're dealing with hundreds, thousands of documents, the likelihood of possibly making an error is high. That's all I have to say. Thank you for your time.
Thank you. Do we have any questions?
Mr. Chairman,
Go ahead, Mr. Watson.
I was curious if the speaker could, if they're using, what software they're using to process requests, and then also kind of rough numbers if they have any just annually for total request volume.
Certainly. We are not using any software. We're kind of creating a homemade database to manage that. A few data points, let me tell you. We did see a sharp increase from we go by fiscal year, from fiscal year 25 to fiscal year 26. In fiscal year 25, we had 26 requests, and in fiscal year 26, we had 67 requests. Also, I think it's important to know that in fiscal year 25, 65% of the requests were from outside of the state of New Mexico and appeared to be for commercial purposes. In fiscal year 26, 47% originated outside of New Mexico and appeared to be largely for commercial purposes, requesting contracts and the like. I think, for companies that take that information, consolidate it, and sell it.
Thank you.
Any other questions? Thank you so much for your comment.
Thank you.
Oh, it looks like we have a question. Who's Foster? Go ahead.
So sorry, I had a delayed reaction to the note about comments, and I'm curious, contracts rather, and it's been a long time since I've tried to use the Sunshine Portal, which I find somewhat cumbersome. I think only applies to state entities, but I'm curious if you'd considered just publishing contracts on a website, or if there's other kinds of information where if you're getting that request a lot, have you considered any options to sort of just publish it affirmatively so you don't have to sort of keep responding to the same kinds of requests?
That's not something that we've considered. We're a local public body rather than, I think, a state entity that uses the Sunshine Portal, but can certainly discuss that internally. Thank you.
Do you have any questions? I'm sorry, I went too fast last time. so much for your time.
Thank you.
Good evening, members of the task force. I'm Mike Stark, and I serve as county manager for San Juan County. I certainly appreciate the opportunity tonight to share our experience administering New Mexico's Inspection of Public Records Act. San Juan County, I just want to make certain, strongly supports the principles that underline IPRA, transparency, accountability, and I think those are very fundamental to public trust. And citizens deserve meaningful access to records that demonstrate how their government operates and spends taxpayer dollars. Our goal with our comments tonight is not to reduce transparency, but rather to ensure that the law continues to serve its original purpose while maintaining practical and sustainability for public agencies that are responsible for carrying it out. IPRA, in our opinion, needs a little modernization to reflect the ever-expanding use of digital resources that certainly couldn't have been contemplated when the law was first created and even subsequently updated. There's just been so much change so rapidly with technology. Since implementing a countywide IPRA records management system, and just to preempt the question, we are using just FOIA. We did so in 2023. We've been able to quantify what many local governments have experienced anecdotally. Between 2023 and 2025, San Juan County has experienced a 21.5% increase in IPRA requests. The overwhelming majority of these requests, 84%, are directed to our sheriff's office, and I know the sheriff will speak to that here shortly. Where responding often requires reviewing and redacting hours of body cam footage, photographs, interviews, and other sensitive evidence. Today in San Juan County, we have approximately 16 county employees that devote a substantial portion of their workload to IPRA compliance. That represents full-time equivalents of 8. And in fact, we're actually bringing forth to our county commission next week and for final budget considerations an additional IPRA position because of the volume of the requests that we're seeing. We also have other employees, of course, that have to respond to these requests from other departments, elected offices, to help process it. And in essence, it's becoming an unfunded mandate with no funding coming from other sources to help offset what we're seeing. These statistics illustrate an important challenge facing local governments across New Mexico. Every hour dedicated to fulfilling increasingly complex records requests is an hour we can devote to public safety, public works, behavioral health services, or other essential services that our taxpayers expect. The burden is growing not because citizens are asking more questions about their government, but in a lot of cases it's increasing because commercial entities are using IPRA as a free data acquisition tool. One example that demonstrates the need for better balance between transparency and practicality is the Sheriff's Office regularly receives requests from companies that produce commercial YouTube and streaming content, similar to the former television program Cops. These companies, request police reports to identify incidents of interest and then request hours body-worn camera footage related to these events. County employees spend dozens of hours reviewing and redacting sensitive video to protect victims, juveniles, witnesses, medical information, and other information exempt from disclosure under IPRA. Yet because these records are electronic, the county cannot recover the personnel costs associated with the extensive work, even though the requester ultimately monetizes the content for private profit. Taxpayers are effectively subsidizing the creation of commercial products that has no relationship to government accountability. Similarly, San Juan County has experienced a growing number of automated requests submitted by bots and AI-driven companies many using fictitious contact information, and refusing to utilize our electronic records portal. We have seen a significant increase in procurement-related requests from out-of-state commercial entities seeking information to market data, analytics, and procurement services rather than to promote government transparency.
So do you have a lot more to share?
I'm sorry?
Do you have a lot more to share? Your time.
I've got 6 recommendations next.
Why don't I ask you, what are your 6 recommendations?
I'd be happy to provide those to you. So we respectfully recommend the following. Allow government entities to charge for time spent for research, retrieval, and redaction when responding to requests. This would be similar to Colorado, Arizona, Utah, and Texas. We agree the first hour could be free and then a $30 per hour, which is a median employee records wage with benefits after that. Perhaps the charges could be waived for governmental entities, news outlets, or watchdog groups. At the very least, the charge for redaction of video would be helpful by not charging for government employees' time researching, retrieving, redacting, and responding to IPRA requests. We are funneling these time-consuming commercial requests to New Mexico. Number 2, enact guidelines that prevent or reduce the use of bots for IPRA requests and require better identification requirements for requesters. Number 3, provide extended response timelines, especially for documents requiring redaction. Number 4, strengthen protections for records that could reveal cybersecurity or infrastructure vulnerabilities. For example, requesting a list of IT vendors seems harmless on the surface until you realize that such a list can be used for exploitation based on who local government contracts with or who local government doesn't contract with. Number 5, we suggest that a requirement be added that if a government entity maintains an electronic IPRA portal, then requesters making electronic requests must use the portal after being informed of the portal. This requirement would be fine-tuned so it does not hamper the average citizen's ability to inspect records. The requester continues to send requests to the wrong portal, there should be consequence to disincentivize that behavior. And number 6, we should explore residency limitations on ways to discourage the commercial exploitation of New Mexico's IPRA statute, especially from out-of-state interests, YouTubers and lots of purchasing related documents and property tax record documents. Generally, these out-of-state requesters are for-profit interests that are turning free government data into a buck at the expense of New Mexico taxpayers. That would conclude my comments. Thank you for the time and the opportunity to share our concerns and recommendations with you.
Any other questions from Tesla?
Mr. Chair, I have a question. Mr. Stark, you mentioned the vendor list that could be requested for an IT vendor. Could you explore that a little, or expand that a little bit? I didn't quite understand how that could be a problem.
Sure, that's a great question. So ultimately, when there are certain vendors that are known to the outside world, especially those in the information technology sector. They know who are successful at protecting government assets and providing cybersecurity services and who are not. Or more importantly, when you have a list of all IT vendors, do you even contract with anybody? Are you providing those services in-house? If you're a small municipality, for example, that may have staff of say 50, you may be very limited on internal knowledge. And so if you don't see that they're using a formidable vendor to provide cybersecurity services, it's an opportunity for that to be an attack vector by outside interests. And so we've seen that as being a legitimate concern and not one that we're able to avoid providing under IPRA. Are we able to maintain and keep exempt plans for how we deal with cybersecurity attacks and response, et cetera? We are. but we're not able to do that with vendor lists.
Any other questions? Ms. Mills, go ahead.
Thank you, Mr. Stark, for your thoughtful comments, and I would just ask that you upload your list of solutions to our microsite so that we can go back and review them again later.
I'd be happy to do so, thank you.
Thank you.
Yes, and I've been asking this question of everybody. I'm trying to understand the bot problem in particular. How are you identifying the bot? Because you said you're getting a lot more bot requests. How are you identifying which requests are coming from a bot? I have also questions about bots, and like somebody, they act at the direction of somebody, I think, right? Like I'm thinking about a lot of bots online that make comments on stuff, but they're not receiving anything sort of back. So anyway, that's my own kind of question about the bot issue, but I'm curious, how are you recognizing the request based on that bot?
So you'll usually get similar type email addresses and or phone numbers that are similar in nature. And then of course, when you try to contact that individual, if you have follow-up information or want to determine, delivery confirmation, et cetera, or, the availability of the record, oftentimes those numbers don't work, or the email addresses, there's not a return. And so that would indicate to us that they're being computer generated and fictitious in nature.
Any follow-up?
Not for me, thanks.
Mr. Williams?
This is my turn. I apologize. Thank you for being here today, sir. I have a few questions because your list of proposed IPRA changes is so extensive as to really fundamentally change the statute as it currently exists. And I have some questions about some of those items. First of all, before we get to your recommendations, you used the term unfunded mandates to refer to what I think you're referring to as the burden of IPRA on your county and other municipalities. Would you be in favor of increased funding from the state to help meet these challenges and the demand that's being put on the county?
Yes, we would. I think that would be very helpful for us, as we've seen just the explosion of requests. Quite frankly, over the last 5 years, as we've seen, like I said, the more requested digital assets, it would absolutely be, in my mind, necessary. We can't continue on this path of just adding more and more positions specific to IPRA compliance while services to our citizens are not being expanded.
Do you see responding to public records requests as not an essential service?
Yeah, it's absolutely a service that we need to be compliant with the law. Absolutely, we want to make sure that citizens have access to public records. No question, that's the only way that you can provide transparency and provide accountability. But it's just become an additionally burdensome because of the volume of the requests and the amount of time that's spent. I just don't think that was contemplated. How could it be contemplated when the law was created? No one could see what we've got today relative to artificial intelligence. In fact, I would argue within the last 2 years, just the explosion of AI and how it's used and potentially misused, right? Not just with IPRA, we can go into Medicaid billing and how now just our local EMS operation here continues to see a high volume of disputes on medical claims because the disputes can be AI generated and submitted without having to have a human involved in that process. And so I'm just giving you examples from other areas of interest that apply to IPRA and how the artificial intelligence piece absolutely needs to be addressed.
You mentioned, I think, that something like 8%
84% of our total public requests, records requests, that include both video and other information are specific to our sheriff's office. And I do know our sheriff will have some additional comments here shortly.
If the legislature were to address the issue of availability of body cam footage, would it be fair to say that would go a long way in decreasing the overall burden on the county in terms of complying with IPRA?
It would be extremely helpful.
And you talked about the possibility of charging people for staff time for compliance with IPRA. Are you anticipating or advocating that those charges would apply to every requester, whether or not it's an individual San Juan County resident or a foreign corporation? Would it apply equally to either?
You know, if there's a way to differentiate, I think that's always the challenge. How do you differentiate that? Yeah, absolutely. I think, you know, obviously a local citizen, you know, journalists or local watchdog groups, those all absolutely should have access. And if you can figure out a fee schedule that makes that, you know, easier than corporate interests that are trying to make a profit or sell data, absolutely, we would be fully supportive of that.
Thank you. I appreciate you answering the questions and for your time.
Yeah, thank you.
Any other questions? Seeing none, thank you, sir.
Thank you.
Who would like to make comments next? Looks like the sheriff up here.
Take the opportunity to piggyback off Mr. Stark, and I want to thank the task force and making your way up to the top left-hand corner of the state. I know it's a long way out of some of your way. I can completely understand why some of you decided to zoom in. But just to capture and piggyback on what Mr. Stark said, we have seen a 21.56 increase in IPRA requests as far as the county. Yes, 84% of those are from the sheriff's office. And just to capture that figure, in 2024, we responded to 4,102 requests. Now, we have done our best year after year of trying to keep up with these requests. And yes, body cam footage is a very hot item or piece of footage that's requested time and time again, especially as our state implemented a law that all law enforcement will hold body cameras. Currently, as it stands, I'm backlogged 143 requests for body cam footage. And year after year, I'm adding more and more staff. So 3 years ago, I added another person in our evidence division to do video redaction. Last year, as we started seeing more FOIA requests coming in, just as far as documentation, it got to the point that it overloaded my civilian supervisors. So last year, we added a IPRA specialist. And just last week, as we're completing our budget for next year, and knowing our backlog in cases, I had to go to the county and ask for another video redaction person within our evidence division. And that came at the cost of $70,000 a year, that's salary plus benefits. It came at the cost of another case guard license, which is $3,000, and that is a recurring expense. And also a computer and monitor at $7,175. And our hope is try to just dig us out of the hole that we are currently in. As it stands in just FOIA, right now we have 242 open requests. 130 of those are from out of state. So you can see that out of state requests are large and continue to plague us. We are always trying to be good stewards of taxpayer dollars, so we looked at outsourcing to different companies to do video redaction. As it stands, what we've found is most companies are charging between $250 and $300 an hour to do video redaction. Now remember that most agencies, such as mine, every officer has 3 cameras on them. They have a body camera, they have a forward-facing camera in their unit, then they have a rear-facing camera for the back seat. So 1 hour of footage is actually 3. If they have a backup officer, now there's another 3 cameras. If the supervisor happens to be there at the same time, that's another 3 cameras. So we're looking at 9 hours on a 1 hour call of video redaction. It has become extremely cumbersome, very heavy lift, and as you can see, very expensive. If I'm looking at just video redaction, people, I'm looking at $70,000 a year. Year after year, this is growing. The question was proposed earlier is, what can the state do about it? Could there be more funding available? I don't think we're gonna fund our way out of this. Having some type of restrictions or something as far as the body camera and where that's plaguing us. Now we can talk about artificial intelligence, the use of different programs that are coming out. We're just not there yet as far as technology, regardless, even if we use some type of AI type software, it still takes a human eye to go through to make sure nothing was missed. Personal information, victims' faces, so on and so forth. So I know we tried this last year. We tried to talk about IPRA reform in last year's legislation. Unfortunately, it was tabled very early on. I don't think this problem is going away. I can sincerely hope that we look at this next year. Yes, we want transparency. Yes, we want to be accountable to our public. But at the same time, there is a high cost of this. And at some point, we're going to have to hit the wall if we're not going to be able to fund our way out of this. It's about being responsible to the taxpayer dollar also. Thank you.
Thank you. Do we have any questions?
Chairman?
Okay, Mr. Watson, I can't see on your screen, so just like jump in.
Yeah. I was curious if the speaker could talk about which body worn camera platform he's using. I mean, I think all of them are relatively cumbersome. I am just mainly curious kind of who's using what.
Yes, sir. Currently, we are using WatchGuard.
Okay. And I'm curious, does that have a redaction function built into it like Axon, or where are you? I'm just mainly out of curiosity, or are you redacting it in a separate program?
We have a program called CaseGuard, which is a product of that. Axon does have its own software. Axon's really pushing a lot of artificial intelligence, even artificial intelligent report writing right now. So I think technology is trying to get there to assist law enforcement, but it's just not there yet.
Mr. Williams.
Yeah, thank you. Thank you for being here. You gave some stats, and I was trying to write them down.
Yes.
The body cam footage, the number of requesters that are out of state versus in state. And you know, we've gotten the impression from other speakers today and in our previous meetings that a lot of the out of state requesters are using them for YouTube purposes or things like that. I'm curious if you know, and you may not, those that are in-state requesters for body cam footage, do they tend to be law firms or media or victims, or do you have any sense of who are the local people, types of people requesting that footage?
I can try to break that down for you. What we have found is 85% of those that are part of my video redaction team, they spend 85% of their time fulfilling individual requests. 15% of their time is spent on archiving video and for discovery for court.
So, well, I'm trying to understand. So, 15%. Who are the requesters for the people for the 15% that ends up for court archive purposes? Do you have any idea?
That's going to be the district attorney's office, public defender's office, private attorneys, archiving the video that may be used in those future cases also. Does that answer your question, sir?
It kind of does. So I think what you're telling me that's 15% of the time they spend. Is that right?
That is correct, sir.
So that's not in response to IPRA requests?
The 15%, no, sir. That would be discovery and archiving. The 85% is off IPRA requests.
All right, so, and I really appreciate this info because we're really trying to get as much as we can from people in law enforcement. So 85% of the total time is from law enforcement, is from IPRA requests for law enforcement video. And a lot of it's from out of state. And I guess my question is for the people that are in state, do you have a sense of who those requesters are? Are they just the DA's office and the defense attorneys, or is it someone else?
No, sir, those are victims, individuals. It could be somebody off a traffic stop, wanting that footage for a traffic hearing. It could be influencers, YouTubers, anybody. News outlets.
Okay. That's fine, and I didn't expect you to have all the answers to all of these questions. We're just trying to get a sense of, because we're getting requests that we make some limitation on the ability to use IPRA depending on your status, meaning if you're a corporation or if you're from out of state. We're just trying to get a sense of who's making these requests, so I appreciate the information.
Do we have any other questions?
Well, Mr. Chair, I have a question then as a follow-up, and I'm sorry if you've asked a question, I may be just asking it again, but as far as the, what percentage of the IPRA requests that you receive are from out-of-state requesters? Do you have that information?
I don't have that information in total. The only thing I can tell you right now is we have 240 open requests, and 130 of those are from out of state.
Thank you.
So about half.
Any other questions? Thank you, sir. Any other folks here want to give comments?
Good afternoon. My name is Glogene Totticini. I'm a member of the Navajo Nation, and I don't have experience in law enforcement or HR or law or the medical field, but I do work with individuals who are in these positions. And I know that we're a litigious society nowadays, and this is when they want evidence and to do their research. So this is good, the inspection of public records. But there is a cost that goes with that, because the people requesting information, they have a responsibility. What are they going to use this information for? If it's just freely given, you just wonder what happens to my privacy? What happens to what's out there in public records? So I think people get concerned about that. And probably if there was a fee associated with it, maybe they wouldn't just haphazardly request it, because some human nature, individuals, are doing it to sabotage or to hurt somebody, or they're angry, and they might use the information in the wrong way. But if the information is used for evidence or research, because bad things do happen sometimes, and you want what is right for the citizen. So hopefully, probably there are some reforms that need to be made. I'm not very familiar with that, but I just wanted to go on record that there is a cost. And I think if people realize if you're going to get this information, you're going to have to pay for it, maybe you're more careful and you're more responsible of how you're going to use this information. And I just wanted to add that. Thank you.
Do we have any questions? Thank you so much. Anybody else here to make comments?
Hi, my name is Adam Howell. I'm an independent journalist from out of state. I come into New Mexico to work on stories. Sometimes I request video, such as lapel body-worn camera, dash camera videos from law enforcement agencies, such as Farmington Police Department or San Juan County Sheriff's Office. So even though I'm out of state requesting that video, it doesn't change the reason for why I'm requesting it. I'm requesting it so that I can figure out the context of what's going on in law enforcement with these incidents. What happened, where, when, how, why. The best way to figure that out is with these videos. These videos also help provide accountability and transparency when they get published on the internet. People see what's going on in these videos. Sometimes they want to redress their grievances with government. They'll call in, they'll notice who these officers are, they'll learn their names, what they look like. People want to know what's going on with our law enforcement. So that's why these videos are important. Sometimes these videos that I request, such as those from officers of Farmington Police Department, they don't get provided to me in a timely, punctual fashion. Instead, public officials take 4 to 4.5 months to provide me with these videos. That's unacceptable. And I can't tell you where the money should come from to pay for these staff to process these videos, but it needs to happen. The best form of accountability comes from these videos. So it needs to get funded, whether it's me funding it or the tax dollars that I've already paid to the government needs to pay for it. The funding needs to come from somewhere, and these videos need to be provided punctually, like within a month, not 4.5 months, not 5 months. I just learned of someone who requested body cam video that took 5 months for Farmington Police Department to provide. That's totally unacceptable. And it's no surprise to me to hear public officials in here trying to bring up the financial part of it more than anything, right? They're not talking about accountability for public servants. They're not talking about the importance of the public seeing videos of law enforcement acting unlawfully, engaged in misconduct. Is that the 3-minute signal? Okay. So I just want to advocate for less restrictions on providing body camera lapel videos from law enforcement. It needs to be provided faster, not 4.5 to 5 months. Those videos need to be provided within a month, no matter how it gets funded. I don't know how that's going to happen, but thanks for your time. You know, if you got questions, I'll hold on to the mic for a little bit.
Thank you. Do we have questions?
Yes, Mr. Chairman, I had a question.
Go ahead.
I'm curious if the requester could speak to where he is based and where his business is incorporated, and then where his journalism is published.
Well, I'm in Colorado, in the Bayfield zip code. I'm not going to give you my exact address because I have a Fourth Amendment right to be secure in my person's papers and effects. And I don't have a legal entity for my business right now, but if I make money, I will establish a business so that I can be licensed and taxed properly.
Where do you publish your journalism? I'm just curious about that.
I publish on YouTube, I publish on TikTok, Rumble. I've got a website, pressfortransparency.com. My YouTube channel is Press for Transparency. My all my channels are called Press for Transparency. So I do print and video journalism. And then I also broadcast live. We're live streaming right now to YouTube. And we're static recording currently.
I'm curious, is your channel monetized? Is your YouTube channel monetized?
Well, I'm not making any money. I don't qualify to make money because I don't get enough views. But if I did, that'd be great. The more views, the better. Always, for any journalist, the more views you get, the better.
Mr. Chair?
Thank you.
I'm sorry. I have a question. You mentioned that, you know, the money needs to come from somewhere and you'd be potentially willing to pay a fee for that information. What do you think a reasonable fee would be?
Well, right now in Colorado, for body cam video of one incident, they're charging me on average about $100. And that's, I would say that's kind of excessive for me to be putting that money into the video, but if it's really important, I'm gonna pay it, right? So I don't know. I mean, it's hard for me to advocate for my own demise financially, right?
Mr. Chair, I have a follow-up question. So, do you find that the fact that you have to pay $100 for video in Colorado, does that make you make more requests to New Mexico or to other states that don't charge a fee?
No, I don't think it impacts that, but it definitely, I think it reduces the accountability for law enforcement in Colorado where I need the videos because I'm not submitting as many requests. So I can't see what's going on in these incidents because I'm not willing to pay $100 for each incident that I want to view. I don't think that's fair. I don't think the public deserves that. I think it's better for the public to be able to see that video.
Ms. Martinez.
Thank you, Mr. Chair. A question for the speaker. For the body worn camera footage that you request from Colorado, do you feel that you get those records in a reasonable amount of time?
Yes, I do. Usually within 7 days, or less.
Got it. Thank you.
Mr. Chair, I have another question. Is the video that you're receiving from Colorado, is it redacted?
They do redact video, yeah. They blur people's skin. Sometimes that software is successful, sometimes it's not. And then, of course, they redact whatever else is required by the Colorado Open Records Act.
Any other questions?
Or the CCGRA Act.
I have a question. You said it was $100 for body cam per incident?
I mean, it's not a flat fee, but just a guess. That's a guess on what I've been paying on average for those videos from a single incident.
And it would be multiple videos from a single incident?
It could be,
Do they tell you what, are you, it sounds like you have experience getting these videos. Do you think they're charging you by the hour? Or do you have an understanding of what basis they're charging you?
I think they are charging me by the hour, yeah. And I don't remember what that fee is off the top of my head.
And we had a question about, like, from other states. Do you request from other states besides Colorado?
I don't remember if I've done any others.
It's super helpful for us to get this perspective, so really appreciate your time and sharing your knowledge with us.
Okay, well, I appreciate the time.
Mr. Chair, I have one more question before
Okay.
you give up your microphone. What percentage of your requests are in New Mexico versus Colorado?
I couldn't tell you that. I haven't been keeping track.
Can you give a guess?
I do so many requests that it's just, it just blurs together. Sorry about that.
can you give me an
Sure.
estimate of how
Oh,
many
my apologies.
requests? I'm sorry for that, I'm continuing on without asking for permission, but, can you tell me about how many requests you make a year?
Over 40.
Mr. Watson, go ahead.
I was curious if the speaker, I mean, if I'm not mistaken, is Bayfield's like within 100 miles of the New Mexico border, is that accurate?
I think so, yeah.
And do you find yourself to be primarily interested in the sort of in the region in which you live?
It sounds like you're asking me if I'm interested in recording public officials in the region where I live, is that what you're asking?
Yes.
I am, I mean, it's more remote where I live, so I'm not gonna be encountering as many public servants in the course of their duties. You know, I come down to Farmington to record public servants in the course of their duties, and so, I mean.
Sure, I guess it's intriguing to finally meet an actual YouTuber, and so I appreciate you coming. I mean, that's sort of what I think of, or how I would characterize your work. But it's I find your testimony extremely interesting because you are from and report on the region around which you live, which is based on the other testimony we've had, is actually not what most entities are experiencing. We're getting requests from Arkansas and Florida, and so I do wonder, I mean, just for food for thought for later, if the residency restriction isn't necessarily residency, but anyone within 100 miles of the New Mexico border.
I mean, it's convenient for me to come down here, and I've got friends down here, so come here to meet with them, and we go work on stories together. There's plenty going on to observe.
Do we have any other questions or any follow-up? I have one question. You probably heard us talking about folks using bots, and we've got questions about bots in other places around the state. Have you ever used a bot to make requests?
Never, no. And as far as I know, IPRA doesn't allow, IPRA, from what I've read of it, it requires the requester to provide their name, address, phone number. So how does that work? How does it, I didn't think these public entities had to respond to anonymous requests like that in New Mexico, but maybe I'm wrong. I don't know, maybe I'm just ignorant on the law, but whenever I fill out a form online, it requires the phone number, name. So I don't understand how that's an excuse for an entity, a public entity, not to fulfill a request. I don't know, I thought, it's like I said, I thought IPRA required certain amounts of information.
Thank you.
Yeah.
Seeing no other questions, we appreciate your comments.
Okay, thanks for your time.
Do we have anybody else who would like to give comments? Well, thanks everyone for sharing your thoughts. This has, just like in other communities around New Mexico, we learned something new every time. I really appreciate all of the input.
Did we check for requests, comments online? Sorry.
Thank you for the reminder.
Okay, yes, I am seeing two people in the Q&A who've indicated that they'd like to give comment. I'm seeing, first is Michelle Rivera Ramirez. I'll make you a presenter and you should be able to unmute yourself. hey, you should be able to mute yourself.
Just a reminder, we've been generous with time, and we're aiming to keep it to the 3 minutes, but we are generous with time.
Don't worry, Mr. Mendez, I will try as much as possible. Hello, everybody, my name is Michelle Rivera Ramirez, and I am Deputy General Counsel for the New Mexico Corrections Department. To start off, the issue around technology, I am unaware of any software that is, of course, cost effective that, you could just input the documents to where, AI or whatever other technology is able to just like redact on a whim. To a previous commenter's point, these kinds of redactions, especially with how, some records, tend to not involve one specific topic, does require a human eye to go through these records. But again, I may be wrong. I'm not the most tech savvy person around. But what records custodians could really benefit from in terms of technology or something of that sort is for either state government or the local state municipal governments to send out whatever kits to records custodians containing redaction software, containing all this software for records custodians to be able to use, and along with that, some sort of training, because IPRA was made, back to my original point last night, it was made in the 40s, 50s, 60s, 70s into Watergate. And there wasn't any advent of the internet or, the technology we currently use for public records. So it's very IT intensive. And again, why are we expecting records custodians who may have a high school associate's education to figure out basically, how to get a record, especially if it's something, technology based. There's one request that we received regarding 7 days worth of video. And our people at the facilities cannot do it on a whim. They cannot do it, within 7 days, because every time we try to download this video, our computers keep crashing. It's just the nature of our technology, and there's no way around it. Sure, you could talk more about funding, but again, there'll come a time. There will come a time if no other improvements are made on IPRA. There'll come a time when the funding that is allocated for IPRA is not going to be enough. It's more of that. Funding alone is not going to solve this. Like I said yesterday, it's a multifaceted issue. It requires more than just funding, more than just personnel. It really requires, some sort of, interaction between the requester and the custodian, like I mentioned earlier. And to end this, we received an IPRA request from somebody incarcerated in Washington who was barred from requesting records in Washington because he was using it to harass entities. And he discovered, New Mexico. He discovered New Mexico Corrections Department sometime in April. And so far, he sent us, I think, 10 requests as of today, around that time. So I find it a little absurd that, you could be barred from requesting records in Washington, which, I've been to, and I don't think it's a very, very restricted place, and come here and on a whim just do the same things, the same behavior that you were barred in the previous state. But with that being said, I'll get right down.
Thank you. Do we have any questions? Who's that? Is that Mr. Watson?
Mr. Chairman, this is Mr. Ethan Watson. I'm kind of curious if the speaker is advocating something for like a, I don't know what you'd call it, but like, what's the provision in the Constitution where we have to respect other states' judgments?
Full faith and credit?
Yeah, like a full faith and credit clause for public records laws, where if, I don't know if that's where you're going, Mr. Rivera Ramirez, but,
Mr. Watson, I don't think I was going there, because, you know, thinking of that, it would really require a good amount of coordination between other states and whether they honor our stuff as well. So I think it's a little bit more complex than what I was trying to advocate for. It was more of issue going back to, my points I made yesterday where, it's not unreasonable to require requesters, a certain set of responsibilities, whether that is put into the statute as, under, sorry, I have my, my little handy physical statutes here, under 14-2-8, procedure for requesting records, a requester must, provide, a timeline, identifiers, because, I can't really find a specific circumstance in mind where a requester knows absolutely nothing of the records a specific agency holds, and yet they're able to make a request to that very agency on what they're requesting. I have yet to think of one circumstance there, but it goes to the point where I believe that requesters do need to have some sort of stake, because when something is free of charge, you think it's unlimited, and it's just partly human behavior at that point. But anyway.
Any other questions? Thank you. Let's see if we have anybody else.
Yes, there was one other person in the chat who indicated they would like to give public comment. My apologies if I'm mispronouncing your name, April Deal Thomas. I will make you a presenter, and you should be able to unmute yourself. Okay, please try unmuting yourself.
Good evening. Can you hear me okay?
Yes, thank you.
Hi, I'm back. I was listening and I was focusing on the technology side of things, and there's questions of how do we know what's a bot, what is not a bot, and the gentleman that from the website, he mentioned that we have to give name, address, and phone number. And I think the one key word missing from the Inspection of Public Records Act is the word valid. Adding the word valid before name, address, and phone number would really help us, because it would help us be able to contact the requesters to clarify, to bring reasonable searches, making things more reasonable and more that we're able to seek clarification from requesters that are that submit broad and burdensome email requests, video searches, and that's the issue that we face, is that we're not able to make contact with requesters to try and help them clarify. But we can't just deny a request and say, no, we're not going to fulfill this because we don't know what you mean. So we have to use our judgment in fulfilling the request, and then thus ending up with an email search that results in 73,000 emails that we have to respond to. And then so we'll send a communication, hey, from what you gave us, there's 73,000 emails, so we'll work on it for maybe a half hour a day and upload what we can on a rolling basis, and then never hear anything back. So that request just remains open, and it's like, are we just sending emails to a bot and, so I think just changing the language of the requirements for a valid name, address, and phone number would be really helpful.
Thank you. Do we have any questions? Looks like
Mr. Chairman, I'd just like to comment, I appreciate Ms. Gil Thomas's comments. I know she's been sort of traveling with us in spirit all over the state, and I appreciate your thoughtful comments.
Very good. Mr. Williams, do you have any questions? Okay. Thank you so much for your comments. Do we have anybody else on? No? That was our last person on. Thank you.
Oh, and I'm also gonna be sending you those, record book, screenshots. I just need to figure out where to send it to, but I'll send it to that email, the group email that y'all posted.
IPRA Task Force at NMDOT.gov.
Yes. Yes, I'm getting that prepared to send out. I'll probably have it sent out tomorrow, but I also want to get with our IT department to see if, to see what the details were in being able to have other entities, utilize that platform.
Thank you. All right, well, that leads us right into our next topic, which was, we're gonna have a kind of focused discussion on IPRA, the technology around IPRA. Mr. Stalter, I think we're gonna start with you and some of what you've been finding, and then, as we discussed yesterday, have a little bit of a free-for-all of sharing about technology and IPRA and how it might help or how it doesn't. But Mr. Stalter, okay to go to you now?
Sure, yes.
Mr. Stalter, I think you're gonna vibe code for us, is that correct?
Yeah.
I don't know what that is.
I could do some live coding of IPRA tools, but in the interest of time, I did put together just a little slide deck of kind of like a case study inspired by some of the comments we got actually from the corrections deputy general counsel yesterday, that kind of shed some light on just one dynamic that I think is happening with IPRA requests. So let me get that slide deck loaded. Okay. Okay, is that displayed for everyone?
Yes.
Okay.
Yeah, I'm not pinning. Oh, got it. I apologize, Mr. Yep, here we are.
Okay, so I was just thinking through the comments of the particularity of requests and that. And I took an example of a request I made to corrections that was commented on as being specific and fulfilled very quickly. So the goal, I de-identified it, but the goal was just to get records regarding a particular corrections inmate about the sentence, how much has been served, and when he's going to be released. I happen to know from experience with corrections that there's a thing called a good time figuring sheet, and that the offender management system portal returns a projected release date. So I have the ability to ask specifically for those things. The ordinary citizen who doesn't necessarily know that background is going to try likely to use something like ChatGPT. It's what people do now. They use AI to help them with these questions they can't figure out. And I've found it very interesting that the difference in the types of requests. So here is what I sent to corrections that was fulfilled very quickly and was commented on as being specific, because I identified these two particular documents that I knew. that got fulfilled. This afternoon, what I did is kind of adopting the position of an ordinary, non-lawyer, but somebody who's curious about these issues. And I typed this exact prompt into ChatGPT. No other instructions, no other context, just a new thread, ChatGPT. I said, I want to make an IPRA request to New Mexico Corrections Department for the inmate John Doe, corrections number such and such. I need to know how much of his sentence he has served and when his release date is. So in an ideal world, that prompt would somehow identify the specific records that contain that information. But what ChatGPT spit out in response to these two sentences and what it recommended that I submit to corrections was this. Something that I think no records custodian wants to receive, because it couldn't identify such a thing as a good time figuring sheet. Now this becomes the request that an ordinary, non-lawyer would be recommended to submit with multiple parts, audit data, records of recalculations, and again, the language that was pointed out in the meeting yesterday, any, such and such, a valid, completely valid IPRA request, but much more burdensome to the records custodian who has to interpret all this. So we've gone from 12 words to 400, four numbered categories, 15 different data elements, all trying to get at the same thing, but without the ability to name that thing, it's being attacked indirectly. So, well, the difference comes from the knowledge of the requester. In this case, essentially, me with my background experience, or ChatGPT, which does its best without full knowledge. And that leads me to some suggestions that aren't necessarily, I don't see as solutions, and maybe this is kind of tangential, but I think what agencies need to anticipate is more and more of these multi-part, detailed, AI-generated requests that the AI tries to be really thorough and will ask for things like audit data, change logs, all sorts of things, and it creates a much heavier lift for the custodians, even though what the human being on the back end actually wanted is the same thing in both cases. Just a couple of ideas for maybe mitigating that in some ways have to do with the fact that the Pandora's box is open. Like, these AI tools are out there and people are going to use them. And the data that these tools pull from is everywhere. In the process of writing that, it did search corrections website and did its best. Like, it pulled out the phrase offender management system, which was almost there. But what I might recommend to agencies is, if there are common forms or types of records, produce a labeled index of what forms and records exist and put it publicly accessible, not necessarily even for humans, but in an AI ingestible, machine readable, structured format, so that when people are using AI to generate their requests, it identifies something narrower. On the other side, one idea for discussion is these portals that are being used for requests could be built with an AI-assisted triage layer that could be instructed and coded to do the reverse, and take all that AI gobbledygook and try to distill it, what that person is actually asking for, and make a suggestion to narrow the request. Now, some people will say no or whatever, but at least you could start to bring it down. And I think the bottom line, like I said, I think the Pandora's box on this stuff is open, and they can't be put back in the box. So it's mitigation and management that might produce, mitigate some of the difficulties with those cumbersome requests. And so that's just food for thought.
Thank you, Mr. Stelter. Very, very interesting. Do we, any questions for Mr. Stelter?
Mr. Chair,
We have one here.
sorry. Well, my first reaction to that was, if we receive something like that, we would probably try to have our IPRA clerk try to contact that individual and see if they can narrow it down, but then that becomes a problem because you can't do that. That in and of itself becomes a very time-consuming problem, and then with the avalanche of requests we're getting, that's something that we would have done. We would have reached out in the past. Another thought I had was you could just request or have it on your page, although I don't know if people read the fine print, but just say, sometimes by just using a simple way of expressing your question may achieve better results. Because I can see getting that type of request, and we would start to go through and try to fulfill it automatically, and it would definitely cause much more time spent fulfilling it when if they just expressed it in plain language like what the input you gave the AI, we could have figured it out probably. By forwarding it to the detention center, then they could have figured it out.
I'm curious about this. It feels like there's a little bit of a conflict in the way that different entities are handling these, which maybe goes back to some of our other conversations about an ombuds or something like that. But because some of what I've heard in the conversation about specificity yesterday was that we shouldn't just be saying, hey, here's my question, right? That was my request. I mean, I said record sufficient to show, but my question was really just, hey, what programs are people enrolled in? But that doesn't identify a document request, which is what I was hearing is sort of the feedback, hey, we should request documents. So it seems like, depending on where folks are requesting, they may be caught between a rock and a hard place. Either it's not sufficiently specific, or it's sort of too specific and in a form that it's not going to get them the documents they're looking for. So it's just, I don't know exactly where the answer is, and maybe it has to do with what phrasing entities are accepting, right? Like, would an entity accept the prompt? I think you're saying they would accept the prompt that Mr. Stelter put into the AI, but would, very understandably, really raise an eyebrow at the actual output of the AI. But I'm not sure whether folks understand that they can ask a question in those sort of simple terms, right? Or whether they're supposed to have to identify the specific things, which is maybe why you get something like, just give me all the emails, or just give me all the video, if folks don't know kind of where to pinpoint that request. So, just continued thoughts on this issue.
Mr. Chairman, I'd like to thank Mr. Stelter for this interesting presentation. I mean, we are seeing this. I think we are seeing citizens kind of randomly submit incredibly complex requests. And so this, I agree with Mr. Stelter. I mean, this is absolutely happening. And I don't think citizens necessarily recognize like how much more complicated the request has become because of what they are asking for. And then what we're also seeing is citizens using, like, I don't know which product, but one of the AI products to correspond with us. So they'll like put our message in or put the trail of next request into it and then say, well, tell me what to say back to the custodian. And so like, I find myself like arguing now with ChatGPT through some citizen. And it's like, it increases, it's interesting because, I mean, I agree with you, the horses are sort of out of the barn at this point, but it does increase the staff time because you're now dealing with like an incredibly sophisticated like party on the other side, which does just make the time spent really complicated. I would say that I do think cost is an answer to this too. I mean, I think if there is what one of the requesters brought up is if there is some sort of cost based on staff time, and if the records custodian says, well, hey, like, sure, I can do all this ChatGPT, but it's gonna take me like 90 hours, and charges come in after 10, I do think that's gonna force narrowing, but I do think it's an important issue to keep talking about. I will say there's a book called Saving FOIA by a scholar named Margaret Quokka. It's an incredibly good book, and one of the things it talks about is there's, I'm not going to capture this perfectly, but there's this notion, I think, that these public records processes are supposed to be this sort of, I think, very customer service sort of bespoke process where the custodian works with the requester to come to this agreement, but about what's sought. But I think there's a lot of tension in that between the need to sort of paper over the request in a way that's legally defensible. And I think that those things are really in tension. And I think the more, I mean, I think a couple of people brought this up, but I think the more that you can encourage sort of a customer service sort of engagement between requesters, that is a very positive outcome. And agencies, but I think the challenge that agencies have is both the legal needs on these requests to sort of handle them in a legally defensible manner, and then also just the volume. I think the volume really precludes the customer service expectations of requesters.
So what do you mean by paper over? If am I understanding that you're saying there could be limits to the communication with the requester because you worry some of that communication could lead to later liability, or am I understanding that right?
Oh no, I think it's that I think because of how the growth of IPRA litigation, I think that a lot of agencies really approach IPRA requests sort of like discovery, all right? They're saying, okay, here the requester submitted these 15 requests. This is like overly broad and burdensome. I need to state an objection here to what the requester's asking for, because we know I can possibly identify this, which is a defensible way to handle it, because you do need to address ambiguities in requests. But I do think that is sort of at odds with the idea of customer service and like the engagement with requesters that we've been talking about. And it's very effective. I mean, Ms. Moskowitz, you highlight this, that when the requester, like the custodian, like is able to pick up the phone and engage with you, you can sometimes come to an agreement pretty quickly about what is sought. And I think that's a thing we want to encourage, but I just, there are parts of this process that make that difficult, is what I guess my comment.
I'm certainly interested in Mr. Salter's proposal that there's sort of a potential for sort of a counter AI, a de-AIing on the entity, and I trust his evaluation of that better than mine, my limits of understanding AI, but it's certainly an interesting suggestion. And it does feel like the AI is not going back in the box as much as many of us would like it to, so figuring out how to proceed from there.
If I may jump in, the suggestion Mr. Salter had is a type of, one of the suggestions, a type of proactive transparency, which was something we were talking about before, the agencies saying, here's what we have.
Oh, yeah.
Right, here's what we have, and here are the types of material we have. One of the challenges that I think we all face is, it's not necessarily that our particular agency may be the generator of the material. As long as we're in possession of it, there's an obligation to give it over. But, and that may be another area where there could be some restrictions. Let's try to get the request to the place that actually generated it. But that was pretty creative, that idea of putting out to the public the kinds of records that are regularly maintained and what they're called, so that when the request comes in, there's some agreement already. That's what I want, that record that says that information.
Sorry. The problem with that is I just feel like it's such an extensive, we have so many different types of records. So I was trying to envision how to create that. I wouldn't know where to begin. It would be such an extensive index. And then I also, as far as having an AI interpreter to interpret the AI request, I just don't know, that's an added expense, and so maybe we'll get to the point where that's cost effective, or if the state were to help us out, but just thinking of, my first thought is, okay, more software that we have to buy, increasing the cost even further. And then the third comment I would make is we're somewhat quick to respond to questions that we don't understand. You know, we just say, can you rephrase your request, because we don't really understand what you're requesting here. And that goes a long way, but it's just getting harder and harder because every day we're getting more requests. Yeah.
Sounds like you've heard from various folks over these listening sessions that some funding from the state for IPRA could help, whether it's technology or staffing, or folks have referred to it a few times as an unfunded mandate, which I don't think is quite right, in that taxpayers pay the state to follow laws, but that doesn't mean that the state shouldn't be investing a little bit more in this transparency infrastructure. So maybe that's will at least help a little with some of this.
One thing we haven't talked about is Mr. Rivera Ramirez from Corrections. What he was describing to me sounded like a IPRA go bag. Here's the whole complete kit of what you need, but in terms of the technology side of it, there's a technology stack of storage, search, and processing, and then delivery. And the challenge I know that we have, and that other entities have, is storage is in a variety of places. Some is on on-prem servers, some is in the cloud, some is in other online services, like an Everloft, for example. And so search then becomes challenging, because then you need a tool to search for each of the places where you're storing. And then there's still paper, right? Like set aside paper, just talking about the technology side. So then you have to invest in search tools, and then various things come out in different ways. Like we know that the body worn cameras, we have multiple providers. Our office is about to get CaseGuard, that seems to be able to handle the various videos that we get for processing. Hopefully that helps, but we've been using Adobe Premiere, and that the latest version is actually worse than the previous version of it. So there's this layering that happens, and each one comes with its challenges. So this.
Can I ask a?
Well, this government kit that he was describing, here's a good way to do it. I mean, who's going to do that? But just, it's needed, right? It's some description of the various technologies and how you search each one, and kind of the IPRA part of it. Go ahead, Ms. Vasquez.
No, I also thought that was a good idea, and I had just a follow-up question based on what you're describing, because that's also been my experience. And actually, I recently took the deposition of a representative of the corrections department, all about how their records are kept. And it's like you described, right? There's some that are in paper, in boxes somewhere, and there's some that are in a software that's used and there's some that just live on somebody's individual computer desktop, and there's some that live, and it seems to me that that's probably not a great, even aside from IPRA, right, that's probably kind of a frustrating system for people, even just within an agency trying to get information. And I wonder if maybe there's an opportunity, or there could be funding from the state to help agencies clarify and consolidate and, make electronic records, so that I'm sure there won't be one single system that could just search every single type of record, but maybe the entities could have a way to sort of consolidate or condense the number of different kind of places they're having to search for records, kind of to your point there about just, there's having to use so many different tools. I have to imagine there's a way to help consolidate some of that work.
Mr. Watson?
I agree with that overarching idea. I mean, I think that in my mind, though, I'd frame it as I think if there was a way to encourage like better records and information governance in entities, yes, I think that's a positive thing. I don't really know what that is. I mean, I read books on government reform about stuff across the country, and it seems like governments everywhere are struggling with like tons of legacy software programs. And it's just, so I agree with you. Yeah, I mean, yes, I think if we were to build all this stuff from scratch, I don't think we would do it the way we're doing it right now. But because we are, we've been around a long time, every agency just has, this is an example. I mean, until very recently, if you wanted certain reports you made, well, sorry, I still have microfilm, to be honest. So like, I'm like routinely searching microfilm for requests. And like, no, I mean, who in the general public is regulated dealing with microfilm? And so, and then like, in terms of software, like we were using this program, it was called the AS400. I mean, I don't even know what was on it. It was like reports from between 1987 and 1996 or something. Like they had some bizarre date range, and only reports in that date range were on that system. And if a requester wanted something in that range, you had to go there. And so I think like, some sort of like big investment in this, and I think there are some. I've heard there's states that do this well. Like I think Pennsylvania has like some good records management stuff, but I mean I think the idea, like, this is a big topic, and I don't know systematically how you encourage. I have not delved into the details on how you do encourage that at a bigger level.
Yeah, I wonder if there's like if the state, again, talking about sort of putting some of that onus on the state, I wonder if the state, initiates a contract with whoever, whatever sort of like company or entity, who can kind of go to the different agencies. I'm also just thinking, right, like the technology, there's all this technology happening, and all of a sudden everybody can do all these crazy things, including submit IPRA requests that are all ChatGPT, and I'm just thinking there's got to be a way to use the evolving technology to support the government agencies as well in responding. But I wonder, I don't know what it would be, but I wonder if there's sort of if there's an overarching, because it would be a big investment on the front end that seems like it could save a lot of angst on the back end once it goes through.
Jumping in here, Mr. Williams, I don't want to put words in your mouth, but some of the teachings of your questions are along the lines of like, there are things we can do to provide relief. And should we be looking at that stuff? At least that's what I've been learning from some of your questions. Like, are there small things that we can actually do that might provide some relief while maintaining transparency? I'm not sure it's on the tech side, to be honest with you.
I mean, sure. I mean, I'm thinking as we go and learning as we go. I think it's been interesting to hear how many different systems all these public entities use for records requests. Specifically in the area of body cam technology, but just responding to requests generally. Some use X requests, some use these various products or programs. I think I've been very surprised to hear that there's not more consolidation or shared technology or any of that. That it seems like all these entities are kind of going it alone. Now I'm not on the public entity side. Maybe you guys can correct me if there's some more sharing of information or technology. I would think that if there is some more shared systems, that we'd be able to share information and knowledge and on how best to use them, and maybe obtain some costs from the various cost savings from the various vendors. I also, when we hear about, some people have complained about some lack of training. And I think the more that we could do, and I don't know who the we is, but the more training that can be provided, considering the turnover that happens, I think, in the records custodians' offices, the better. So if you're asking, Mr. Mendez, about what are some changes that can help people without changing IPRA, these are some of the things that come to my mind. I mean, and just to close off on that point, I mean, I agree with what one of the speakers earlier today, I think it was the sheriff, who said you can't fund your way out of the problem. I do agree with that funding has limitations as a solution. But I also think it's clear that especially for some of these smaller entities, they don't have enough people, that they are struggling to turn other jobs into records custodian jobs. And that there are entities that would really benefit from going from one full-time person to 2 or 2 to 4 or 6 to 8 or something like that. And I think that as long as there is an increasing demand, we're going to have to somehow deal with that from a funding standpoint.
Mr. Stoyer and then Ms. Martinez.
This may not be directly on point, but it seems, and maybe you're still providing these classes, but the Attorney General's office used to tour the state and give information about IPRA. Do you still conduct those classes?
Yeah, those classes still happen.
Okay, good.
I think one idea that's come across here has been the idea of like an ombudsman that might do a more robust service to all entities that have to answer IPRA requests. Ms. Martinez, go ahead. And then Mr. Stalter, later.
Thank you. So just on the lines of, software systems, I know that there was a comment about, it sounds like there's many different systems. There's really like a handful of public records software systems that are being used and that are even out there available on the market. In addition to just a handful of like the body-worn camera footage software systems that are available and being used. I think on the side of like trying to figure out ways to help public bodies, municipalities, the Municipal League not too long ago was looking at various software systems that may be able to use AI to help with redaction. And, unfortunately, we have not been able to find anything that really meets the need of municipalities. A lot of people are talking about AI, even, in the examples, and Mr. Salter, I think that your presentation was great, and yeah, just kind of thinking outside the box. But, because of the fact that so many people or agencies are, we're all subject to, compliance of IPRA, it'd be very hard to implement, AI to sort of translate what a request is and use that to fulfill a request. Not that, I'm not open or, the records custodians are not open to different ways of looking at things. I just think that, there's high stakes and, even for us who are looking for things, the New Mexico Municipal League to, take on financially and then help and benefit our municipalities in responding to records requests, it's still, these are hard to find software systems that are going to stand the test of time, be accurate, for use.
And Mr. Stalter, go ahead.
It strikes me in a lot of these discussions that there might be something to be said for pulling certain functions whether it's review, whether it's legal advice, whether it's the portal platform software, to a statewide program. An interesting parallel, I think, comes from retirement funds, actually. In most other states, every municipality has its own retirement program. At some point, New Mexico made the choice we'll have like a couple different funds, PERA for all public employees, and employees from different municipalities, counties, state agencies are all paying into that, and it's one fund, and it's administered by the state, statewide, and that, I think, actually saved a lot of municipalities. In 2008 and the fallout of that, we saw municipalities in California and so on going bankrupt because of pension demands and other things like bond debt service. But New Mexico, I think, was a little bit insulated from that because there was a statewide program. So maybe there's a parallel in IPRA of maybe it's the ombudsman's idea, maybe it's the state providing a software platform that kind of unifies requesting and production. Maybe it's providing counsel, maybe it's storage, but taking the strain off, because you've got all the different counties, all the different municipalities are essentially doing the same thing in some sense, reviewing and redacting. IPRA is the same for all of them, right? And every little pocket has had to develop its own system and its own way and its own approach to addressing these challenges with widely different resources. So if some of that could be pulled to a centralized location for the state, of course, who's going to fund that and pay for it? And I have some ideas, but we can get to that later. The centralization in a state with New Mexico's, geographic and demographic profile, there might be an argument for it, especially because it appears to have been a benefit in some other public functions.
Interesting. Mr. Watson, go ahead.
Yeah, I think it's definitely an interesting idea. One minor variation on it worth considering is that I do think it's when I think there is a case to be made also for more JPAs around purchasing next request type softwares or just FOIAs for small entities or school districts or even small executive branch agencies. I think if for every agency that gets less than $500 requests a year, it's probably not worth it to get an extra request on their own. But if you have 3 or 4 of them, they could band together and something like that. But that leads to some level of more of the fracturing we're talking about right now. But so some variation on Mr. Stalter's or pooling, I think, within different types of entities, I think is a really interesting idea.
I think that idea would also, I'm sorry, I think that idea would also lean into easier training. If lots of people are using similar systems, then there could be more group training, and there could be a lot of money saved in that respect as well.
I'd just like to jump on that too, because I think this is especially true about body-worn camera, because not only is it complicated to review it and identify the things, but the softwares themselves are also all pretty complicated. And Mr. Mendez, it actually hadn't occurred to me that your office deals with multiple formats. We have the benefit of only dealing with Axon, and I think Axon's redaction platform and processing system is pretty good because it's all pretty integrated. But that's interesting that you all deal with different formats, and that's really a curious thing I hadn't considered.
And and video of all types, right? So you might have video from security video, you might have, right, so it's not just the lapel cam. Well, like we did, yesterday, we're kind of blending this agenda item with our, next agenda, just discussion, right, so, yeah, go ahead, Mr. Lawson.
Just like a sort of on a practical question, because we're talking about, the possibility of different kinds of software and the possibility that perhaps entities could join in one. What are the next steps for something? Because I know Ethan and Rebecca were talking about having looked into some things at different points, and I'm just wondering whether there's somebody for the state that like investigates new technologies, or where would that interest or responsibility, if we were to recommend that to the legislature, that they sort of explore, any number of these sort of avenues. Do you all know, like, who, would they come up with some kind of a committee? Is there like a technology expert that would handle it? Just, curious about the practical next steps of something like that.
I think they could get addressed in the report as like, we could pick some place to put that work. I don't think
assign it.
Yeah, and say this is work that needs to be done. These are areas that could be addressed. So I think that's the place we put it in terms of just our work.
Yeah. Mr. July. I thought about this as well when we were talking, so I really love the program in New York that funds sort of just digitization writ broadly, and will just basically pay people to digitize stuff. But in that program, I think lives with their Secretary of State, but I couldn't, when I was like looking around at this, I couldn't really find a good place for it to live in New Mexico's structure. So I think that's a great question, Ms. Moskowitz, about kind of like, where do you put these things? Because they all sort of fit within one umbrella, but they don't. I don't know that they currently have a home. I mean, I think some combination of like state archives do it or something like that, or maybe the ombudsman, right? I mean, maybe that's the, and I think also one thought is like, kind of what is the specifics? Like if you're talking about a grant proposal, like that's, like a grant system might be easier to administer than like, I don't know, like some sort of full-scale cloud for agencies to store their stuff. I mean, that might be more, I don't know what that looks like, but, I did have some quick numbers, Mr. Chairman. We had, Mr. Stalter and others, I think, had wanted to see I liked your summary of like the tech stack, and I don't know if that's of interest to focus on like how much this stuff costs.
Yeah, I think that's a critical importance.
So for example, I think Next Request and Just FOIA and GovQA, like my global impression is they're like 10 to 30 grand a year, depending on your volume. So like we spend currently around 25,000 a year for Next Request. We do have like a legacy contract because we've had it for 10 plus years. I don't think they currently offer our model, but I think that's kind of a ballpark on their cost. The city does, to Ms. Moskowitz's question yesterday about like a content management platform, the city does have an enterprise content management platform called OnBase. We spend around $80,000 a year on it. We do store a ton of information. So for Init, for example, we store all the city's HR files and various other types of sort of classes of records in it. I will say it's like, we've tried to move like global sets of records in there, but it's hard to get, it's not a great candidate for storing them kind of day-to-day, like records that people use just kind of in their work. For lapel camera, the city uses evidence.com or Axon. That's about $500 per license for my staff, and we only have access to the redaction module. And we don't have cameras. Like if you actually have a camera, I think there's a separate cost to that. Rebecca, I don't know if you can speak to that, but I think the municipal league does like buy cameras for agencies sometimes, but yeah, I mean those, but and then there are like, we do use Adobe Pro a lot. I think that's probably a couple $100 a license. There are other programs out there, but yeah, and then we use Everlaw. We like Everlaw a lot. It's a great email processing tool. It's very effective. It does have some AI components to Mr. Stalter's question. I mean, I think the two biggest programs where I've seen AI kind of really attempting to be deployed are Everlaw and Axon. I think they are really trying to work on this. I don't think the AI in Axon, from what I've seen, is like, it's useful, but it doesn't replace a human, and you still have to watch the stuff, but it's getting better. And then the Everlaw, I'm not familiar enough with its AI product yet. I mean, we're really getting up to speed on this, but I'm not in the weeds enough on the AI aspect of it to really tell you like how well it works, but we do like it.
I can say where Everlaw helps as in deduplication. It does a good job of that.
Yes. Yes.
And I was just clarifying about you said Everlaw is an email processing, or it's part of what you use for email processing?
Yeah, it's an e-discovery platform.
Okay, so it's like, it's something you can use when you're trying to produce emails. How does that work? Like the emails are just sort of input in and then it gives you a way to search them, or?
So we conduct our searches in, like, Mr. Mendez, I'd be curious to know how you do this, but what we do is we conduct our searches in Purview, and then once we've got the searches, we upload them into Everlaw, and then we'll dedupe them, and then we sort through them and tag them to see if they're responsive or exempt or whatever, and then you can export the results, and yeah.
We do that same process. Yeah, so
Another dumb question.
No.
What's Purview?
Purview is Microsoft's search tool that searches emails, OneDrive, SharePoint, searches their product suite. Google will have its own. Google's is called Vault, similar, right, kind of the powerful search tool. But that's only one tool to search those systems.
Can you do like Lin searches and that kind of thing? You can do it. That's helpful. So it sounds like, because we're hearing from some folks that people requesting emails might be able to help out custodians by offering search terms or that kind of thing. So that's helpful to understand.
I think with emails, it's important to remember how common some words are in news articles, for example, right? That lots of people get.
That's why I asked about.
So an email search returns thousands and thousands of records. It takes a long time.
Part of why I asked about Boolean searching, because I've had that problem too, where I want to offer help, but if it's just I can only search a word, that it becomes sort of useful, where I don't know if you can search this word in the emails of this particular person, or this combination of words, and then, sort of different iterations of that.
I think it's not just, I think, hopefully starting to coalesce in folks' minds. Maybe, appreciate everybody's thoughts today, contributions. Any other discussion we wanna hit upon? Like I said, we're kind of blurring this agenda item with the next agenda item.
I do think there's more, the comments tonight around, just piggybacking off what Ms. Moskowitz said about email searching, I do think that agencies needing to request greater particularity from requesters on and I think frequently don't, and I don't know, I guess what I want to try and dig around into is I can try and circle back with the task force on this, is I don't know if there's other public records laws that just offer better guidance on what is reasonably particular. But it does fit, and maybe the answer really is what the requester was commenting on, that we should with email offer. Because IPRA currently does this with lapel, is you can't just request like all lapel under the planet. You have to, it actually says in the act that you have to be like pretty specific. And so I wonder if like something similar with email is necessary, because I think it's a similar challenge.
Yeah, it'd be interesting to try to figure out the right line there, because the request that the person was commenting, which is sort of like everyone's emails for a period of time, which even to me seems not reasonably particular. But I don't know that the provision to lapel wouldn't necessarily translate directly to email, right? Particularly because you have no way of knowing, it's not like you've read all of people's emails before, and you can be like, hey, send me that one, or know exactly what time, but there could be a way to address that, or to, for custodians to, ask for those kind of search terms, and be assured that they're sort of permitted to wait for search terms from somebody, or, there may be ways to kind of address that are specific to email. Right, just to give custodians a little more guidance on the particularity question.
Well, and on that particularity question, we've been getting requests that give us a link to a video. Like, we want the stuff in that video. We seek clarification on those because it's like, well, what are you talking about? But that's been an interesting new trend that we've started to see a few instances where there's a link to a YouTube video and a request tied to that. I don't know if that's reasonably particular.
Our position on that is that it doesn't if they're requesting lapel video, that it doesn't satisfy that provision of IPRA that specifies that they need to provide that, yeah.
We do the same, but it sounds like there's some guidance that's needed. Like, if we make a request of somebody and they'll respond to us, we'll say, hey, we'll give them like 15 days. Hey, let us know in 15 days. We can't process your request because we don't know what you mean, and the statute says reasonable particularity. We don't think that's been met. Please give us an answer by this date. If you don't, we'll consider your request withdrawn. And that's been our practice, because otherwise you end up with a ton of open records requests. And a lot of times people just end up abandoning it because they don't reply. And it may be that they're bots, and so they don't reply because they're bots.
Go ahead.
I would like to, that reminds me of the comments earlier about where it sounded like one entity was sort of endlessly producing emails to a bot that was not responding. And I do think this highlights to me the need for reform of IPRA's fee schedule. The city we do get pushback occasionally on our practice of producing emails on disks, and we don't transmit emails unless it's less than 10 pages over Next Request or through our platform. But the challenge we've seen is that if we don't have some way to ensure that the requester is still interested in the request or is willing to pay for some portion of the production costs, some portion of the actual costs, that you do end up just with lots of uncollected records, or records where it's not clear that the requester has any interest in the records. And so, I do think that fees, I think there's a discussion to be had around, what are appropriate fees? Should there be waivers? Should they be only in certain types of users? But I do think that fees serve a very important role in public records laws, and sort of ensuring that public entities aren't spending massive amounts of time on requesters who don't want the records or have no involvement in the request.
I see a clear.
Ms. Martinez, go ahead.
Thank you. And I guess along those lines, and we've all been taking notes on public comment, this notion of fees and, within the process has come up quite a bit. So I do think that, in relation to that, I think entertaining a conversation is noteworthy. And also looking at what we currently have on the books, and how that can be used, or whether it's useful to public entities.
Go ahead, Ms. Moskowitz, and then Mr. Stahl.
I just feel like there's two distinct issues here, and verifying that a requester is still interested in records seems to be one of them, and makes some sense to me. And this other one is fees, and I don't know that they're the same thing, but I'm really wary of increasing fees because New Mexico's a poor state, and there's a lot of people who cannot pay $100 an hour of video, or who can't pay, whatever the fee may be. And I do think it's really important because what ends up happening then, right, is you end up getting just the requests from the big entities that can pay money for them or who are gonna turn them around for a profit. And I think that sort of is actually something everybody has been identifying as maybe not the purpose of IPRA. And so I'd just be really wary about thinking about poor New Mexicans who may be submitting IPRA requests and protecting their right to access the public records as well.
Mr. Chair, I have a comment along those lines. We've given a little bit of thought to that. And I just wonder if there could be some form of affidavit that a requester could fill out if it's kind of a form stating that they can't afford to pay the fee. Just those exist in a lot of different areas. That might be a way that you could take care of that. And then you would assume that if it's a corporation, that they're always going to have enough money, you know, that they wouldn't be able to claim that they can't pay the fee. But for individuals, they could fill out an affidavit potentially. Of course, there'd be people who would probably not tell the truth, but at least that would be a mechanism that you could use potentially.
I think there would need to be some consideration of the media. The media might qualify as corporations and have a commercial purpose, but they are absolutely strapped. Some of them are independently funded. We've lost one and maybe two local newspapers in New Mexico this year. And so I would just be careful about using the corporate designation as the divider between who we choose to charge and who not to.
Ms. Watson?
Yes, sorry.
Go ahead, Ms. Mills. And then we go to Ms. Watson.
No, it's okay. I was just gonna say that I put a lot of thought into this, and, you know, the gentleman that was speaking earlier, the journalist, you know, talking about it, because there will be a time where we have to differentiate between the YouTubers that are out there for entertainment and monetization and people that are actually doing actual news reporting. And I don't know that it's going to be, we have to think about, are we going to define it by like who they work for or the type of content that they put out? And I've done some research around that, and maybe next time I can bring some information back to the group on what some other states are doing. Is, you know, we have to be careful, how do you define a journalist and what does that mean? And, you know, and the Press Association, we've looked at that closely because we've expanded like our membership. You don't have to be a newspaper to be a member of the New Mexico Press Association anymore. At one time you did. There's a lot of news sites out there, and I was looking at this gentleman's his YouTube channel. He's doing stories. You know, he's going out, he's boots on the ground, gathering information and putting stories out there. It's not just a bunch of videos for people to, you know, gawk at and monetize. So if that's okay with you, Mr. Chairman, I would like to bring something next time prepared for the group to talk a little bit more about this, because I've known from the very beginning that this was going to be something that came up that we needed to talk about. And, you know, there are some states that are looking at different fee schedules, you know, depending on what you're using it for. And so I'll just leave it at that. But, you know, we have to be careful because, you know, the Albuquerque Journal reporters work for a for-profit business. And so I think that's what Mr. Williams was getting at. We have to be careful there.
That's appreciated. Before we have more comments, right? Mr. Stelter, I skipped you, so sorry about that. We can go Mr. Stelter, Mr. Williams, and then Mr.
A couple things. I think when I raised my hand, I was about to make essentially the same point that Ms. Moskowitz made. But I do think worth exploring in the context of different forms of media, journalist, entertainer, there's, I think, some constitutional considerations in terms of viewpoint discrimination. And I think I have some homework to do before I'm satisfied for myself that I really understand those parameters, but they are out there. One thing for consideration, though, in terms of, well, to respond to a comment that was made about inserting the word valid before name, address, to me, I already think that's implied in IPRA. I just can't imagine that it would be a reasonable construction of law to say, provide a name, address, and contact information, but it can be fake. I just can't imagine a statute requiring identity information permits that information to be false. And I think the issue is more that there's no verification or enforcement of it. And especially if we get into any discussion of residency, like sliding fee schedules based on in-state or out-of-state, there needs to be some reliable form of verification. I notice a lot of state governments for various benefit programs, like unemployment insurance in different states, are using this ID.me verification. And I wonder what agencies in New Mexico, such as unemployment, are doing for identity verification to confirm this is a real person who's eligible for these benefits in New Mexico, and so on. If the discussion goes in the direction of residency confirmation, just food for thought.
Yeah. Mr. Watson, and then thanks.
Yeah, I agree with Mr. Stalter, sorry, and that I think maybe it's that IPRA needs to be clear that an entity can deny a request if a requester provides a fake name or fake address or like something like that, because I agree with you. I think the statute already suggests that like the name should be valid. I mean, to be honest, we did fulfill a request from Scooby-Doo this year, but you know, it's a great point. And I also want to feedback on Ms. Mills' comment. Like and Mr. Williams, I think that finding a drawing line on who is media is like really challenging in our day and age. I think that is really ambiguous, and I prefer in general things that are less subjective as someone who has to administer the act. And so like, I think residency is like a little easier to administer in terms of some dividing lines. Like, and I'd be curious to know from Ms. Mills or Mr. Williams, like, there are states that do have these carve-outs for like media, and I think FOIA has one where it's like media entities over 5,000 users or 5,000 subscribers, but like I'm very curious in practice if those actually serve any gatekeeping function or any like limitation, or if functionally everyone just qualifies now because they're, you know, I mean, I guess there's not really a lapel camera at the federal level, and so that's maybe where there's not going to be a clear answer on that, but I just, I think if we're as a group, we're exploring if there are sort of useful limiting principles. I think the media one, I agree, is really complicated because I'm just not sure where or how you draw that line, and then like how you provide records custodians across the state with a standard that they can actually apply.
Go ahead, Ms. Mills.
I believe under the federal FOIA standard that they don't qualify as a representative of the news media if they're just reposting raw footage. And they're not using editorial skills and shaping stories.
Well,
I don't know if that helps, but that's a thing.
Yeah, I'm just probably echoing what's already been said, but as someone who would have to administer this, it does, I hate the idea of having to verify who people are, what they are. So maybe it would be better to, if you're going to charge, just have the charge be, have a charge in place, but have it be that it's not onerous to the broad spectrum of the public, you know. I think even any charge would probably, would help, because I do feel like requests are being funneled into New Mexico because this is a place where you can get it all for free. And, I think that even a $10 charge per request, but I don't wanna put a lot of work, we're gonna end up making it even more work for people having to respond if we're having to somehow verify and get new software that can determine someone's identity and that type of thing, so that would be difficult.
Any other discussion?
I was just looking up what percentage of New Mexicans live below the federal poverty line, which is an obscenely low number to begin with. That should be used for much of anything at this stage. But just thinking about what fee might sound reasonable to anybody in this room, might in fact be onerous to somebody who's not sure where their next meal is coming from. So something to keep in mind. And perhaps as we're talking about out-of-state requesters, maybe if we go that route, it's not that out-of-state requesters can't request records, but perhaps out-of-state requesters have to pay some sort of fee rather than sort of prohibiting those entirely. Might be able to split the difference there.
One more thing, Mr. Chair. You've probably discussed it in other meetings, but I feel like if you were to try to prohibit out-of-state persons from making requests, that they would just spring up companies that would, act as an agent in New Mexico. You probably discussed that but anyway, this is the thought that I've been having.
Well, there'll be more time for more discussion, and I think every time there's a lot of learning that happens. We have on our agenda, we always have on it, discussion and possible amendment of the outreach plan. Is there anything we want to do there, or we fine with how it's been going?
Mr. Chair, do we need to amend the work plan to talk about fees at a subsequent meeting, or does that already fall within what we had slotted for?
We did vote on that, and it did get prioritized.
Well, and we always have our discussion item, right? We have that open discussion item with each.
Perfect, okay, so we can talk about it there. Okay, sounds good.
Mr. Chair, I was gonna ask if the committee was open to flipping the order of the next series of meetings. The only reason I raise this is I would love to be in town for the Albuquerque meeting, but I'm unfortunately gonna be out of town, and so, but I will be here on that Monday. If it's too much work, I can just attend remotely, but I would love to be at the Albuquerque meeting in person.
Is that a motion?
That's a motion, but I don't feel strongly about it. If the committee feels that, I won't be offended if the committee votes it down.
What are the dates that you're proposing, the switching?
So the next meetings are in August 3rd, August 4th, August 5th. I'm going to be out of town the 5th, and so I could attend, if we could basically just switch the order of those meetings so that Albuquerque was on the 3rd, that would work for me.
Could I propose something a little bit different? I have scheduled meetings in Santa Fe around some of this. If we could just switch the Santa Fe and Albuquerque meeting and do Albuquerque on the 4th and Santa Fe on the 5th, would that work for you? Because that would work better with my schedule, because, yeah.
I don't think there's been a second, Mr.
Yes,
Chair.
yeah, there hasn't been a second. Is there a second or a revised motion?
I'll take Ms. Mills's amendment as a friendly amendment, so moving Albuquerque to the 4th. Do I have a second?
I second.
Motion is second. Now discussion. Mr. Williams.
I am sympathetic to Ethan, but I really think that we have advertised these meetings for a long time. I think the Albuquerque and Santa Fe ones are probably the ones that may get the most in-person attendance. It's only, what, a week or 2 weeks away, I guess, for these. And I would like Ethan to be able to participate because I think he's an important member of the task force, but I am concerned about a late change at this point.
Ms. Moskowitz.
I was gonna make the same point, just that these have been advertised for quite a while, and I happen to know there's some folks who are making plans around those, already.
All right. Do we want to go to a vote? How strongly do you feel about the motion, Mr. Watson? We'll vote.
We got a mark in a second, it's fine, I'm it's voted in, so it's.
Let's do it. Mr. Stelter.
I have to go first. Then I'm no.
Ms. Mills.
Yes.
Ms. Martinez.
Yes.
Mr. Williams.
No.
Ms. Moskowitz.
No.
I'm gonna chicken out. As not a regular member of this committee, I feel like I should abstain. Unless you need a deciding vote.
I think that's, oh, Mr. Watson.
Yes.
We will need, well, who are we at? I'm gonna vote no.
I appreciate the committee's consideration.
It failed, yeah, the motion failed. Council has to make sure I said that. Okay. Any other business on that?
Ethan, if you'd like, I'll be your proxy for that meeting.
Oh, if,
You can take that under consideration.
noted.
We are the ones who don't get proxies. We have to be there.
Oh, that's right.
That's true, that's true.
Yeah, we perhaps should have, modified that, but I was just gonna say, I will be sending a proxy to all 3 of those meetings, because I will be on vacation, so I'll look forward to hearing about them at the deliberation meetings.
Let's see, this is where at this closing, just to make sure we inform the public, best way to submit written comments is iprataskforce@nmdoj.gov, that, or going to the microsite on the NMDOJ website, there's a thread of comments there. And then, lastly, our next meeting didn't change, it's at in Las Vegas on August 3rd at 4 p.m. at the Luna Community College. And with that, we're good.
Can I ask a quick question? On the written comments that get submitted, do those get posted? I was looking at the website, I couldn't find it, and I wasn't sure.
They're supposed to get circulated to the community.
Oh, I haven't seen any.
Ms. Zeritsky, will you have Ms. Zeritsky address that?
Yeah, so the written comments that are submitted to the IPRA task force at ndoj.gov are added to a running Word doc, and those have been sent to task force members. I'm happy to send another email after this meeting that will also include that running document. It is within a folder that includes all additional files that have been sent to the task force as part of public comments as well.
And that includes the ones submitted through both the email address and on the website, right?
Yeah, so the ones submitted through the microsite are sent automatically to that email address. So it includes ones that are sent directly to the email address and ones that are submitted through the microsite.
And it's a running doc, so once you have it, it just keeps getting added to.
And you're,
I'm sorry, that's a folder that gets sent to us, is that what gets attached to an email?
Yes, so there are past emails where there will be a link to a folder, and within that folder there will be both the running doc and all other files that have been sent to that email address as part of public comment.
Okay, thank you.
Okay, now with that, we're good. Thanks so much.
What's up, Johnny? Jenny, thanks for the moderation help. That was a long one.
What an interesting meeting.
Right?
Yeah, that's good comments.
Oh, thanks. Thank you.
I think they got some real good information from you. Like, I was real glad that you spoke up, man, especially from hearing it wasn't sounding good, especially out there saying how they're getting a lot of out of state.
It was
I think you gave us some good, different perspective.
Thanks, man. It was pretty biased
Yeah.
in favor of the establishment.
Most definitely.
The comments, you know, like lots of public officials and people really who didn't seem to be advocating for transparency, but rather for saving the taxpayers from the financial burden of having to pay staff to process requests, right? And
It was kind of scary hearing what some of the managers had to say. Anyway, yeah, that's cool.
I'm gonna end the stream right now, guys. Thank you all for joining. I know it was a long one. Keep pressing for transparency, though. Have a good night.